In this video, we'll discuss common partnership disputes and what you can do to avoid them. There are lots of disputes that can arise between people after they start a business together. And in this video, we're going to cover the most common types of business disputes. The first is when somebody doesn't receive access to information. And this usually happens where a minority business owner is locked out from receiving information of the business from the majority owner. And this usually happens when the majority owner is the manager of the business and the minority owner doesn't have nearly as much control. This may happen when the business relationship goes south or where there's a lack of communication between the business members. So how do you avoid this? Well, the solution here is to have provisions in your operating agreement that give members the right to inspect the books of the business. Now, most state statutes require LLC managers to treat the other members fairly, but it certainly doesn't hurt to have those spelled out in your operating agreement from the beginning. And this ties into the second type of dispute, which is breach of fiduciary duty. And before I get too much into the weeds, what is a fiduciary duty? Well, it's a duty that says that the members and managers of a business must act with the best interest of the business in mind. Examples of these fiduciary duties include the duty to not compete with the company and the duty to treat other members of the company fairly. And when there are disputes between business members, breach of fiduciary duty is a very common claim that's brought in court. And in recent years, courts are getting a lot tougher on this issue. This is because the members and managers of businesses do have a duty to treat the other business members fairly. And so what can you do to avoid a lawsuit to begin with? Well, it's important to have the manager's duties spelled out in the operating agreement at the beginning. And if you are a business manager, the last thing that you're going to want to have happen to you is for you to go in front of a jury and say that you treated your business partners fairly. And if you're already in court, they're likely not going to believe you. However, if the manager's duties are spelled out in the operating agreement from the get-go, then the chance of them being sued for breach of fiduciary duty in the future are less likely. The third common partnership dispute is uneven workloads. And this is where one member puts in more time, labor, and sweat equity than the other members of the business. This certainly drives the hardworking member crazy. After all, in many cases, this could be unfair. So what can you do to avoid this dispute? Well, there are two things that you could put in your operating agreement to prevent anything bad from happening. The first is to include operating agreement provisions that prevent business members from working elsewhere. And if you have this in there, they'll be required to devote more time and energy to the business. And another thing you can do is include an operating agreement provision that provides for distributions based on the amount of hours worked. And in this case, the person who works more hours gets a larger distribution than the people who don't. And this ties into the next type of partnership dispute, which is non-pro rata distribution. And this is where the managers of the business don't distribute money based off the ownership percentages. So as an example, if you have a 50-50 partnership and one of the managers makes a 90-10 distribution in favor of themselves, in that case, that would be a non-pro rata distribution. So what can you do to avoid this situation? Well, the first thing you can do is to require pro rata distributions in your operating agreement. And another thing you can do is requiring 2 or more members to sign off on a distribution before they're made. And if you have both of these things in place, you're likely going to avoid any non-pro rata distributions. The next common partnership dispute is misappropriation of funds. And this is where an LLC or business member improperly takes money out of the business for their own personal purposes. And this is a big issue because at the end of the day, it very well could bankrupt the company. So what can you do to avoid this? The first thing you can do is by requiring 2 or more members to sign off on a distribution before it's made. The second thing to do is to have buyout provisions in your operating agreement if one of the members conducts illegal activity. The next common partnership dispute involves people who have a 50-50 deal. And this is where you have 2 members of the business, each of whom own 50% of the business. And this could cause issues, because if both members disagree on something, this could cause a deadlock. And when there's a deadlock, the only ones who do well are the business attorneys. So what can you do to avoid this? Well, you can have a tie-breaking provision in your operating agreement, whether that be a coin toss or having a neutral third party decide and be that third vote. And another thing you can do is to add a third member who can own 1% of the company. And in that case, they can be the tiebreaker in the event that there's a deadlock. And the last type of common partnership dispute is when the minority member decides to walk out of the business. And this is where somebody with a small ownership percentage decides to leave the company. So what can you do to avoid this? Well, you can include provisions in the operating agreement that allow the business or the other members to buy out the minority member's interest. And with these in place, the company can continue without any disruption. So, in conclusion, as you probably noticed, the best way to avoid these partnership disputes is by having an operating agreement in place from the beginning. So what is an operating agreement? Well, an operating agreement is the governing document of the LLC. And on top of that, it's also a contract between the LLC members that all of them must follow. And it's best practice to have an operating agreement when you start your business. Because when you start your business, there's no disputes between the members. However, after 2 years, each member could develop their own narrative about what they did to contribute to the business or how the other members treated them. And the best way to avoid any disputes when that happens is by having an operating agreement in place that governs what happens when a dispute arises. And if you need help drafting an operating agreement or setting up a business, we here at Corporate Direct would be happy to help you out. You can schedule a free 15-minute consultation with us by clicking the link in the description below. I also have a new book called The 5 Tricks to Teach Your Kids About Money. You can download the book for free by clicking the link in the description below. If you're looking to start a business, you can schedule a free 15-minute consultation with us at Corporate Direct by also clicking the link in the description below. And as always, please make sure to like, subscribe, leave a comment, and turn on that notification bell. And I should warn you, the contents of this video are not legal advice and no attorney-client relationship has been formed.